Hello, everyone. Good evening, and welcome to our live Monday night special from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Hope you had a wonderful weekend. Hope you're well rested because it is going to be a very busy week in true crime. And we are very honored that you have decided to join us this evening for us to go through what to expect in the week ahead. Hello to Janelle Rodenbar and Bess Nancy and Mimi D and Afton and Angela Robbins, therapists Wendy Jones, so many of the names that I recognize, so many members, actually. That's really impressive. Thank you guys so much for all your support and for rolling deep, as they say. And a lot of new names. So hello to you if you're new, if this is the first time that you're ever watching this channel. I appreciate you being here. Let me introduce myself. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years. I left to go into private practice as a criminal defense attorney. This is Courtroom Confidential. That's the name of our channel, where we try to bring to you both sides of the courtroom, and we hope that we do that. And this is our live Monday night special, which is kind of a look at the week ahead, what to expect, what's on the docket, what things may have taken place over the weekend. And we actually do have some updates of things that took place late on Friday, over the weekend. Some stuff happened today, so a lot for us to jump into. Stay to the end. We do have some announcements because this week our programming is going to be a little bit different. I'm going to be doing some traveling, which is fun. I'll tell you all about that and why I'm traveling and where. If you haven't already, I'm going to give you one quick moment to please go ahead and like this episode, to subscribe if you haven't already, to share this with somebody who you think might enjoy it. But let's jump in, shall we? First of all, on Friday, a case that I know that a lot of you have been following very closely, because we followed it closely on this channel, and there is always enthusiasm about it. A lot of questions every Sunday fun day, is Donna Adelson. Donna Adelson had, so to catch everybody up, she was convicted. The verdict came in September 4th. By September 15th, her attorneys file a 57-page motion for a new trial, to have the verdict thrown out, to interview jurors, just a bunch of stuff. And not to say that this is not important, but this is kind of par for the course. This is what attorneys do at the end of a trial. They immediately start to file a bunch of paperwork to kind of CYA, quite frankly. They're making sure that they cover all their bases, file everything that they need to file, because a lot of times, we've talked about this many times, defense are doing things to set up possible appeals. And if you don't make those objections, you don't make those arguments, then you've got nothing to bring up on appeal. So one of the things you do is immediately say, we want a new trial judge who just oversaw this trial, Judge Everett. We don't think you handled it properly. We think you were a little bit biased. We think that jurors got out of hand. And for all these reasons, we want a new trial. So that was a big motion that they filed. In particular, they are saying that the use of jailhouse informants was improper. There was over-reliance on the jailhouse informants. I felt that the jailhouse informants were some of the more important testimony used in that case. I mean, it was a jailhouse informant who was the person who connected Donna Adelson most directly to the planning of the murder. A jailhouse informant said, Donna told me she did this. There was no other evidence that direct. Everything else was circumstantial. And then also they drew a lot of criticism, or I should say they criticized some of the jurors. Juror number 7, who identified herself as the jury foreperson, we all know took TikTok. There's a freeze frame from one of her videos where she talked freely about the case. And also juror number 5, who went on our good buddy Joel Waldman's channel, Surviving the Survivor, and talked about his experience during the trial, and in particular talked about his or how he received Donna Adelson's very emotional response to the verdict, I should say. Well, on Friday, Judge Everett, because he's the best and we all love him, and he's got no time for your nonsense, denied everything. And here's what he said in particular to the jurors. He said, the defendant did not object to the jurors being able to disclose that limited information. He was saying there was some limited information that the jurors were allowed to talk about, and they had all discussed this. And juror number 7's TikTok posts comports with this exception to the communication prohibition. Defendant cannot now use juror 7's compliance with this directive as grounds to interview her. So it was basically like, you guys agreed that the jurors could talk about certain things. She did talk about certain things. You can't therefore lay a trap for her to go ahead and talk about those things and say, well, now we want an opportunity to interview her. As I was reading this, I was wondering if that was the first time that Judge Everett had ever put the term TikTok into one of his official rulings. But I thought that was very, as was everything he's done on this case. I thought it was a very smart ruling based on the law and the facts as they played themselves out, and very fair. Also, there was a lot of, we saw this coming, and I expect we will see it revisited again on appeal, but there was a lot of argument about whether or not she was given, Donna Adelson, enough time to decide whether or not she was going to testify. When you guys watch this, you remember there was a lot of drama in court, and she's saying, I haven't made up my mind, and I need more time. And the attorneys are, kind of giving each other side eye saying, can we get another 5 minutes, Your Honor? And then it was another 5 minutes on top of the 5 minutes. And he finally said, okay, it's enough. It's now time to, or stand up. And his ruling on this in regards to their arguments was, the court concluded, meaning himself, I will make no further inquiry unless the state or the defense seeks for the court to do so at this point. So he's saying, I said in court, I'm done unless you have something else you want to say. Neither party did. Accordingly, defendant was provided sufficient time to, and did, make a knowing, voluntary, and intelligent decision not to testify. Again, he's smart. He set things up properly. I think more than anything, this man showed incredible patience throughout this entire case to make sure that it was handled properly. And I am very confident that the Court of Appeal will see it the same way. So his final conclusion on all of this was that the court does not find the arguments presented in this claim warrant a new trial. The court does not find that the jury's verdict is contrary to the law or the weight of the evidence. That's it. It's done for now. They have a status conference coming up on October 15th. No sentencing date has been set, but don't worry. In case you haven't had enough of this case, they will start filing appeals sometime soon. They're just waiting for appellate attorneys to get assigned. They're waiting to file their briefs. They're waiting for the record to be set. That's another thing that needs to be done. They need to take all the transcripts that are pertinent and decide what is the official record to send up to the Court of Appeal. So stay tuned on that one, but that is what happened on Friday. Jude Evans, thank you so much for gifting the membership. Appreciate that. Jude, looking rather fierce there in your emoji. Cat Flap Carnage. Oh, I missed it. Cat Flap Carnage says, do you think the jurors should be able to talk publicly about their experience on a jury, especially a big one? I do. I mean, listen, they've got the same First Amendment rights that all of us do. I think they should be allowed to talk about it publicly. I think they should be admonished how their public statements can cause issues. This is kind of a phenomenon that we've seen, I feel anecdotally. I've not done a study on this, but I feel anecdotally we're seeing this far more than we used to. It's not like jurors speaking publicly, it has all of a sudden been invented in the last few years. They had before done tell-all books. We've all seen that. They had before spoke to the media. But this idea that now we live in this age where all you need is a phone and a TikTok account or a YouTube channel, and you can immediately go out there and broadcast without any kind of intermediary your message to the entire world, and people will consume that in greater numbers than we've ever seen before, I think is a fairly new phenomenon. And jurors are starting to use that. Jurors are taking to Twitter. We saw that in the Karen Reed case. Jurors are taking to TikTok. They're going on YouTube podcasts. Again, I think Transparency is good. I think information is good. But I do know that if I'm wearing my prosecutor hat, I'm sweating bullets every time I hear these jurors start to talk, because I certainly don't want it creating problems. But great question, Cat Flap Carnage. Annalie Finch, thank you so much. Always so generous. Wishing you continued success with your channel. Well, thank you. I appreciate you saying that. All right, let's move it on to Laken Snelling then. This also took place on Friday. She is the young woman, she's 21 years old, who, a really horrific story. On August 20th, what is now being called a fully developed, full-term baby was discovered inside of her closet, wrapped in a towel, in a plastic garbage bag, in her closet in Lexington, Kentucky. She was a cheerleader at the University of Kentucky. Since that time, she's spoken to police, she's made certain admissions, and she's been charged with abuse of a corpse, tampering with evidence, and concealing the birth of an infant. But notably, she has not been charged yet with murder. Now, the Fayette County coroner has said that more testing is needed to determine the cause of death and gestational age of the infant. I don't know what I don't know what that means. I mean, I know what those words mean when you put them together and string a sentence, but I don't know what they're saying as far as what testing needs to be done and what that testing might be. And maybe we need to get a guest on here to explain that to me. But I'm a little confused that we're now, over a month later and they still cannot tell us whether or not that baby was born alive. We have new information coming out from police. They've released some statements that she made to them. She apparently told, or police have described the baby as being full term. I already told you that. She has told them that after she gave birth, that she passed out and woke up. She apparently passed out and fell on the baby. This is a little bit graphic, so I apologize to you guys. I'm going to try to keep it as mild as I possibly can, but she passed out on top of the baby, woke up to the baby turning blue and purple is her description of it. And then she later told hospital staff that the baby made a whimpering noise and that at one point, and again, we're going to have to, this is so difficult when you're taking, this game of telephone from the statement made from someone to hospital staff, from hospital staff to police and, law enforcement, to then into their report. We don't know how much of this is direct quotes, but somewhere in there, she said that the baby made a whimpering sound and that she guessed that the baby was alive. That is obviously not a very small point. That is a crucial point in all of this. And whether or not determining, is this a murder? Is this manslaughter? Is it involuntary manslaughter? What is it? We're talking about the taking, Kathy Davidson pointed out, she admitted the baby had fetal movement. Again, is she using that term fetal movement? I don't know. I can't imagine her, a 21-year-old, using the term fetal movement. So she's probably describing something to hospital staff that then describes it to law enforcement as that. And then it's therefore attributed to her as a quote. And I don't know if any of that is true. And if we'll ever get to the bottom of it, if any of these conversations were recorded. But obviously we're talking about, if you realize that this baby is alive and in distress and you do nothing and allow it to die, that could be some form of murder or manslaughter. And even worse, if you then facilitate that death by wrapping that baby in a towel and in plastic and allowing it to simply die. Now we're getting towards murder. Now we're pushing the definitions of what was her intent at that time. In any case, the latest is that on Friday she waived her prelim and is now heading to the grand jury. Again, we've talked about this before, but every jurisdiction has a different way of handling what is called their probable cause determinations. When you're charged with a felony, you get some sort of probable cause determination. Actually, a misdemeanor too, but let's keep it to felonies. You get some sort of probable cause determination, meaning somewhere a judge or a grand jury is going to have to make a determination. Is there enough evidence, not beyond a reasonable doubt, but a much lower standard, a probable cause standard, to believe a crime was committed by this person and what that crime is? In many jurisdictions, they do it through prelim. In other jurisdictions, they do it through grand jury. In some jurisdictions, you're allowed to choose. And here, it sounds like she is choosing to waive her prelim, and therefore it will head to a grand jury. Somewhere along the line, someone's going to have to make that determination. Now, why does this become so important? Because though she has been arrested, and this is true, by the way, for most cases, the police don't decide what you're charged with. The district attorney's office decides what you're charged with. Police can arrest you for anything. They can arrest you and say, we're arresting you. You're arrested for allegations of murder. And they present that case to the DA's office and they go, this isn't murder. This is involuntary manslaughter at best. And that's what that person is charged with. So this evidence will now be presented to a grand jury. And a grand jury, the prosecution will ask them to return an indictment. They will suggest charges, and a grand jury will decide, is there probable cause to charge her? Those charges can include manslaughter. They can include murder. Just because she is currently charged with abuse of a corpse does that not mean that that cannot change after the grand jury. So stay tuned and stay buckled up, because I believe that we may be getting much more serious charges out of this case. Certainly, if any of the evidence that we're hearing, these statements that she made, the condition of the baby, if any of that proves to be true, I can't see this being anything but some sort of homicide, some degree of homicide. Again, whether that's from involuntary manslaughter to first degree murder, it's some homicide taking place here. So, like I said, I don't have a future date for that case yet. The grand jury is going to be set, but I don't know if it's been set just yet. If you got no dates, let us know. And if you have questions on that, I'll go ahead and take those now. Let me see. Granny Detective says, because Laken now has to wear an ankle monitor, does that mean that additional, more severe charges are coming? Not necessarily. I think that even with the charges that she's facing, abuse of a corpse, tampering with evidence, those are serious charges. They can come with a very high bail. I mean, the idea that she's wearing an ankle monitor is certainly better than her being held on some sort of $1 million bail. But again, the grand jury could change all of that. If they indict her on murder, I imagine they're going to set a very high bail, and she's probably not going to be on some sort of home monitoring. I think that initial valuation on the ankle monitor was based upon the initial charges, what she was brought in on, what she was originally arraigned on, and their assessment of her flight risk, her threat to the public. Probably both of those items are very low. But the seriousness of the charges could obviously change. Thank you for that, Granny Detective, and good to see you, as always. As 1990, thank you so much for the super sticker. Appreciate that. A Wood Now, thank you again for the super sticker. Appreciate your support. All right, let's get to our next case here. This is interesting. This, again, was over the Friday, or over the weekend. Friday, I think it was. You may remember a case called what has been referred to for some time as the Yogurt Shop Murders. In fact, HBO did a very thorough documentary series on this, and I highly suggest that you guys watch this. Now, if you watch this, I will say, bear in mind what I'm about to tell you changes things about all of this dramatically, but it is a horrific murder that took place in 1991, December 6, 1991, in Austin, Texas. Everything tonight probably deserves a little bit of a graphic warning, but again, I'm going to try to be as straightforward and not as salacious as I can with this. But 4 children, young women, Jennifer Harbison, age 17, Sarah Harbison, her sister, age 15, Eliza Thomas, age 17, and Amy Ayers, age 13. They are not all of them, but I think a couple of them, maybe three of them, and this or two of them, and the sister joined, and then a younger friend working at. You guys may remember these yogurt shops back in the day called "I Can't Believe It's Yogurt." Again, this is in Austin, Texas. Towards the end of their shift, someone comes in. They believe that that person attempted first, perhaps a robbery. There's a lot. This case deserves a lot more attention than I'm about to give it. So I'm not going to give you as many details as I could. We could do an entire episode on this, and maybe we will. But they are eventually tied up. They are each shot in the head. Their bodies are found stacked on top of each other, and there's also evidence that they may have been sexually assaulted. And then the yogurt shop is burnt down. And why that's important is that it made the forensic analysis, retrieval of any kind of remaining evidence extremely difficult. In fires, it's not only the fire, and in fact, probably far less the fire that poses the problem as much as it's the fire department and their use of water to put it out that destroys a lot of the evidence. It turns into an absolute flood, and all of that gets washed away, and all of the evidence goes down the drain, literally. And that's what happened here. So they had very little to go on. But you can imagine in 1991 in Austin, Texas, this was all that anyone was talking about, a quadruple murder of young women, and they've got no suspects. Again, I'm giving you the very shortest version of all of this. Flash forward shortly after that, a young man by the name of Maurice Pierce, who is 16 years old, makes some sort of confession about this, saying that he supplied a gun to another friend of his. Flash forward to 1999. So we're talking 8 years later, police decide to revisit this case. And you have to imagine, too, the pressure on law enforcement during this time. 8 years later, and the most horrific murder, headline-grabbing murder in Austin is still unsolved. They revisit this confession by Pierce, and they discover other people they believe to be involved. Another young man by the name of Forrest Welburn, Robert Springsteen, and Michael Scott. So if you're looking at this photo, it's Maurice in the top left, Forrest to his right, Robert in the bottom left, and Michael to his right. They all are interviewed. And this is where this fascinating concept of coerced confessions, whether you want to call them that, whether you want to call them adoptive admissions, where the person doesn't quite understand what they're admitting to, whether you want to call them false confessions, whatever it is. But this concept really rears its ugly head in this case. And Maurice, who originally said he was involved, retracts his confession. Forrest Welburn makes no confession. Robert Springsteen makes some sort of confession, and so does Michael Scott. Springsteen and Scott are convicted. Springsteen gets the death penalty, and Scott gets life without parole. Now, jump forward to 2004. The Supreme Court of the United States overturns those convictions for a couple of reasons. One, there's no physical evidence linking these men to the murders. And two, there was recent Supreme Court precedent in a case called Crawford v. Washington. Very famous case in criminal law dealing with hearsay and where you can use the statements of a person, a hearsay statement where that person is now unavailable. Is there ever a circumstance where an unavailable witness who made prior statements can have their statements played in court without the ability for the defendant to cross-examine that? Based on that precedent and other issues, their convictions are overturned. Well, while I'm sure some in the law enforcement community were very bothered by that, now that brings us to today, because through the use of advances in DNA testing and ballistic analysis, police now believe that a man by the name of Robert Eugene Brashers is in fact responsible for those 4 horrific murders. And this man had a very extensive rap sheet. In 1986, he was convicted of attempted murder out of Florida. In 1990, he was accused of murder out of South Carolina. In 97, he was accused of rape out of Tennessee. And in 1998, he was accused again of double homicide out of Missouri. So he, since the time of these murders and before, had an incredibly violent lifestyle, and they were able to link him to DNA recovered from the scene. Will we see his trial? No, we will not, because he took his own life in 1999. So this announcement merely kind of puts, hopefully, an end to this, so that this is no longer an unsolved mystery and cold case, or that people believe that those responsible, got out of it by some sort of legal loophole. But it sounds like the man responsible was, in fact, never apprehended, never brought to trial, and took his own life in 1999. So, interesting update. Isn't this similar to the 4 men that Johnny Depp stood up for? Not sure about that one. Not sure about that one. Thank you for that, Barb, and I'll get back to you on that. Southern Cali B says, I went down the Fred and Rose West rabbit hole over the weekend. My word, would love to hear your thoughts on that one, Josh. Of course, not tonight. However, my mind was blown. Well, I will write that down. Make a note of that, everybody. Fred and Rose West. We will definitely look that up. And hey, by the way, great question for Sunday Funday, because then you basically kind of forced me to answer that question for you. But thank you so much, Southern Cali B. All right, let's move it on to another case that was kind of, I don't know if you want to call it solved or yes, they were released. Sorry, I just saw that question from therapist, says, and were the 4 guys released? Yes, they're all out. They're all out of custody. Like I said, 2 were never brought to trial, 2 were convicted, and everybody's out now. All right, Travis Decker, horrible case. That's just kind of the running theme of this evening. Horrible cases. This arises from the horrific discovery on June 2nd of this year of 3 babies. Peyton, age 9. Oh, I can't even look at that picture. Beautiful, happy little girls with their hair all done up, just loving life. Peyton, age 9, Evelyn, age 8, and Olivia, age 5, were discovered with their heads wrapped in plastic bags and zip ties, dead by asphyxiation. And their father, Travis Decker, who was going through some really contentious custody issues with their mother, Whitney Decker, was gone. He had last had the girls. It was kind of a missing persons case for a little while. Then they make the grisly discovery of the young girls, and then they can't find him. And if you've been following this, you know that there was a very extensive manhunt for him that took place over weeks. Like I said, this was back in June. So they'd been searching for him since June. The girls were discovered in Chelan County, Washington, in an area called the Rock Island Campground. Well, just 3/4 of a mile away from there, his remains, or remains of a body, were found, I should say, and they confirmed on Friday through DNA testing that that is in fact the body of Travis Decker. I don't think we've got further information at this point as to how he lost his life. It sounds to me like it likely was self-inflicted. given the, close proximity and what he likely did, before taking his own life. I'm just kind of speculating here. Another kind of thing that stood out to me is 3/4 of a mile. We might think to ourselves, well, that's close by. But when you're talking about in campground, wilderness, wooded areas, that's a large area to search when you're searching for remains in a heavily wooded area. I don't know, how mountainous that whole area was, but they had grid searching done out there. So less than a mile away, a body was found, and we can now confirm, because police have confirmed, that was in fact his body. So bringing an end to that manhunt, but certainly not an end to the trauma and loss that will be never end for Whitney and her family, having lost those 3 beautiful little angels. And I can't even bring myself to really kind of explore how horrific the final moments of their life were, when the only person on earth that should have been protecting them was in fact hurting them. And horrific stuff. So that's kind of the end to that case, I guess you could say. Like I said, it's not the end of that story, but it's certainly the end of the manhunt, and whatever kind of criminal case is obviously not going to happen now that their prime suspect has been found dead. All right. Let's move it on here to today. Now that was all from last week. Now we can finally bring ourselves to Monday. Earlier today, and in fact, I know about a lot about this one, is Tyler Robinson. I was on Fox News earlier today talking about this quite a bit, but he had his hearing. Tyler Robinson is obviously the man who's now been accused with capital murder for the assassination of Charlie Kirk. Couple of things of updates. One, he's been assigned an attorney, and that is a woman by the name of Catherine Nestor. There she is there. She made her first appearance today. He was first in court about 2 weeks ago, I'd say. That was his, or what they call his felony first appearance. And he had no attorney at that time. So they put things over till today for his attorney, who has been appointed by the state, to make an appearance. Catherine Nestor, who is she? She's got 30 years experience. She's incredibly qualified. She ran a couple of public defenders' offices before. She, in fact, was the former head of the public defender's office in Salt Lake City in Utah. So she's very ingrained in the criminal defense community there in Utah. And you may also recognize her name because she represents another defendant that we've talked about a lot on this channel, and that is Corey Richins. Corey Richins is the mom out of Utah who's accused of murdering her husband by spiking his Moscow Mule cocktail with fentanyl and taking his life. And she continues to remain in custody and has her trial approaching any day now. Well, Catherine Nestor's got her hands full because she's representing Corey Richins, and now she's been assigned to represent Tyler Robinson. And you may be asking yourself, why put more on this woman's plate? Why are they assigning this case to her when she's already got a very high profile murder case? Couple reasons for that. One, we'll get into this a little bit later, but the Tyler Robinson case, I don't think is going to see the light of day for trial for a very long time. And that may disappoint a lot of you, but we'll talk about the reasons for that. But two, because Tyler Robinson has been charged with aggravated murder, and because the state of Utah has indicated that they are intending to seek the death penalty, they can't just assign this case to anybody. Certain jurisdictions have public defenders' offices, and others assign cases to attorneys that are a part of a panel to get assigned cases. But those attorneys on the panel, even those attorneys who are public defenders, have to be qualified to handle a case of this seriousness. Here's something interesting. Had the family of Tyler Robinson had the money, they can hire whoever they want. They don't, there's no restriction on going out and hiring some guy who advertises for DUIs on a bus stop. They can hire whatever attorney they want. There's no rule that says you cannot defend a case unless you are have handled death penalty cases in the past. What the rule is the state won't pay for it unless that person is qualified. So this is going to be a state-appointed, taxpayer-funded defense, and they're not going to put that towards somebody who's not adequately qualified. Well, that really limits your choices, your options when you come to some of these jurisdictions where they might not have all that many people who are death penalty qualified as a defense attorney. So I think it could be a combination of her availability and her qualifications that she was assigned. But nevertheless, she has been assigned. She made an appearance today. And what happened? Well, today was called the waiver hearing. Again, it's so funny on this channel as we just explore other cases, in other different states. I'm constantly being educated on how they handle things just a little bit differently. It's like we all speak the same language, but everybody's got really heavy accents. So you have to kind of pay attention to what they're saying and pick up on these different dialects. Well, in Utah, they have what's called a waiver hearing, and that's where it's up to the defendant to either waive prelim or ask for a prelim. Well, I mean, we have that same option here in California where I practice. A person can waive their prelim if they want to, but most people, 98 out of 100, get their prelim, want their probable cause hearing. I don't think this case is going to prove to be any different, even though Catherine said today that she hasn't made a determination on that. So maybe there's something in the state of Utah that I don't quite understand where there is kind of a interest in waiving prelim. But to me, your client, the defendant is looking at the death penalty. I cannot see them waiving any rights, any opportunity to fight this, any opportunity to see what the prosecution's case is and to test that out, because I just can only see it causing problems later on. Here's what she had to say, though. This was in court today. She says, until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelim. In my view, that's saying we're going to do a prelim. We just don't know how much time we're going to need to do the prelim. So they asked to push it out an additional 30 days. In that 30 days time, the prosecution plans to turn over evidence. Now, the prosecution was in court today, being led by a man by the name of Chad Grenander. There he is. Along with a team of prosecutors, by the way. He announced, I think, like 5 people. He's described it already as voluminous discovery. And I can't imagine it being anything less. Think about this. We're talking about all sorts of digital evidence, not just the defendant's phone, but the phones of everybody who happened to be recording that event, the phones of everybody he was communicating with, the Discord chat, any digital footprint that this person had. Then we're talking about DNA evidence recovered from the rifle, recovered from the bullet casings. We're talking about all of the people that he may have been talking to. All of them need to be identified and interviewed. And then this was a murder committed in front of hundreds, if not thousands, of eyewitnesses. How many of those people do they intend to identify and interview in the pursuit of this case? Now, do I think that that means that the prosecution, if this goes to trial, is going to call everybody who happened to be in attendance that day when Charlie Kirk was speaking and got murdered? No. I think that would be foolish. I don't think a judge would allow it, but there may be some sort of reason why the prosecution feels like they need to interview quite a bit of those people, and why some of their testimony might become pertinent and important for the trial, because the way that we get to aggravated murder in this case, he's been charged with aggravated murder. Why is that important? Aggravated murder allows for the state to pursue the death penalty. Aggravated murder requires an aggravating circumstance. In this case, it is a murder committed while putting other people's lives at risk. Who are those other people? Some of the people who are in attendance that day, some of the people in the crowd, some of the people standing to the left or right of Charlie Clerk or even behind him. And those people may certainly have to be called to testify to just establish that aggravating circumstance so that the state can even pursue the death penalty in this case. So my point being, when you really start to think about it, this is a true use of the word voluminous. And I think that they're going to be turning over gigabytes upon gigabytes of information to the defense. What does that mean? It means what Miss Nestor had to say is that she can't even tell you how much time she needs till she gets her head wrapped around how much she's going to be handed. So they're going to come back on October 30th for their next court date. Basically, nothing happened today other than they moved exactly what was supposed to happen today to October 30th. He has still not entered a plea. He has still not pled not guilty. He has still not been, in my view, arraigned for the charges. He's been advised of what they are, but he has not entered a plea. So on October 30th, they expect to come back. They expect to perhaps have him enter a plea, and then they will expect to make a decision on a prelim. Again, I would be shocked if they didn't ask for a prelim. And if they do ask for a prelim, don't be surprised if they say, we would like to have a prelim, Your Honor, and we would like to have it 6 months from now. The other thing to keep in mind on this is because it is a death penalty case, the judge is going to be handling this with a very soft touch. And this judge, he sounds like he's very good. His name is Judge Tony Graff Jr. He made statements in court about how, I don't care if the world is watching, everybody's got rights. We're going to allow this person to fully exercise their rights. Translation in my head, that probably means he's going to be giving a lot of deference to the defense, especially when it comes to things like asking for more time. A lot of comparison was made today to the Brian Kohberger case. And if you remember in that case, how long it took, that was a case that, yes, you had more people who were murdered, but the complexity of that case, as far as the evidence, I think you could argue there's more complexity in this case than in that case. Maybe not. But in any case, if that case took several years to go to trial, expect perhaps the same out of this case. It again also being a death penalty case, and expect the same blueprint. I think the defense is going to spend the lion's share of their time challenging the death penalty in this case. I have heard a lot about the evidence. You guys have heard a lot about the evidence. We've heard about admissions that he made to his romantic partner, admissions that he may have made to his mother and father, DNA, videotape evidence, cell phone evidence, all this other evidence. This to me is not coming down to a whodunit for the defense. This to me is coming down to a, can we possibly save our client's life and spare him the death penalty? And because of that, they're going to do exactly what they did in Kohberger and try to challenge that death penalty in any possible way they can, whether that be legally saying that it's an abuse of the Eighth Amendment and cruel and unusual punishment, or whether that be to attack the aggravating circumstance and say, well, that's not what's intended by putting other people's lives in danger. Whatever it is, that's what they're going to be going after for the next several months, in my view. Oh, one other interesting thing about this case. I did a little bit of thinking about it today. He is, and if you've got questions, I'll go ahead and take them now. He is charged with aggravated murder, which we know is the important one. He's also been charged with felony discharge of a firearm. Again, kind of a no-brainer. But he's also been charged with 2 counts of witness tampering and 2 counts of obstruction of justice. And whenever I see these cases, that it's obviously this case is a murder case and nothing else. And when you start to see these other charges being added, you have to start to wonder, why is that? And it usually isn't just the prosecution piling on. There's some strategic thinking behind it most times. And I'm wondering if they added these obstruction and witness tampering charges to give them a better opportunity, an easier avenue to bring in some evidence that they might not otherwise, that they might have otherwise had difficulty bringing in, i.e. Discord chats, i.e. some conversations that he may have had with people before and after the murders. The murder, elements of the murder is, did he take this man's life? That might not include things like having conversations with people about, hey, delete this text message. Hey, I'm trying to get away with this. Here's my attempts to get away with it. I don't know. That's just kind of where my brain started to go with that. I'm wondering if by adding those charges, and because they need to prove those, is it going to give them an easier opportunity to bring in some evidence that may have had some difficulty otherwise? All right. Jen H says, since the defense/state is saying that this has to be handled so carefully, what's a ballpark on costs? Could the federal government press any charges? Let's take the second part of that. I don't think the feds are going to touch this one. The state of Utah has the death penalty. They're pursuing the death penalty. The feds couldn't be bringing anything, to add to that. The feds also, I think, have a difficult argument in why they gain jurisdiction here. I think they're looking into the Discord chat to see if he was communicating, planning, conspiring with people who may have been out of state or out of the country. That could possibly be an argument, but it would be a stretch. Under what mechanism could they bring charges, and why? Would it be helpful, or would it just further complicate things? They will certainly provide resources through the use of their investigation and the FBI and analysis and everything else. But as far as like actually bringing a federal indictment, I don't see it, and I don't see the reason for it. Sorry, could you go back? But since this is handled so carefully, what's a ballpark on cost? I love that question because a lot of people want to know, what is this going to cost the state? Hundreds of thousands, into the millions? Perhaps, yes. Here's the thing, though. One, you don't want prosecutors thinking about that, right? They should be pursuing justice with a blind eye to the cost. Now, you may say, well, wait a minute. What if they're just going off on some wild goose chase and wasting our time and wasting our, therefore, taxpayer money in doing that? Well, that's a problem in their pursuit of justice, not so much in a problem in the taxpayer money being spent. Prosecutors are there regardless if they're going to trial or not, okay? So you've got detectives and prosecutors and everybody else, and they make their salary. It doesn't go up or down based on the complexity of the case or how much they work on it. They don't ask for a higher retainer just because the case is more complex and they're going to be working on it more. They're just doing their job. They're clocking in and out. Law enforcement, coroners, forensic investigators, prosecutors, they're doing their job. So if they're pursuing this case or they're pursuing a bunch of DUIs, it's kind of the same amount of taxpayer money, quite frankly. And I hope that they don't think about money. Now, that does get a little wishy-washy when you start to say, well, they're going to bring in outside special prosecutors, or they're going to hire experts, and how much money are they going to spend on that? Then I can guess you can start asking those questions. But I appreciate absolutely where you're coming from, Jen H. All right. Kathleen Craighead says, so will we get to watch this trial? Yeah, listen, they've allowed cameras in the courtroom. The judge today wants him in court. It does. Nothing about this so far. They've got a quote unquote gag order in place, but that's not, as onerous as we saw in Idaho. I think we will. I think this will be a televised case. Certainly all the hearings have been televised so far, if that's any indicator. But thank you for that question, Kathleen. Kaylin, who's that, says, I saw a few days ago, Utah County Commission approved $1 million for staffing to support prosecution and defense efforts. Well, there you go. Again, I don't know if that means that they need an extra $1 million for their budget, or they're just allocating $1 million towards this that might be allocated elsewhere. I don't know. I don't know how into the weeds on that whole funding issue I can get on this. And then Pammy, thank you so much for the super sticker. You are so kind and generous. Appreciate you. Tia M says, what, if any, is the difference between a targeted murder and an assassination? I think they're synonyms of each other. I would say, I mean, assassination, I'm using that word because I feel it's the best descriptor, but it's certainly not the criminal definition of what he's charged with. He's charged with murder. He's charged with aggravated murder, but it's not like assassination makes it an aggravating factor. It's just, in my view, I guess, to your point, Tia, if you target someone and you are targeting that person based upon that person's beliefs, what they stand for, what they are, what they are as a symbol, to me, that starts to drift into the definition of assassination, but again, has nothing to do with what he's charged with criminally. All right, let's move on to Lindsay Clancy. Another horrific case. This one is out of Duxbury. I'm probably pronouncing that wrong, Massachusetts, because I feel like every name in Massachusetts, you have to say it like Duxbury, or I don't know. I'm probably saying it wrong. January 2023. Lindsay Clancy is suffering from, she just had a child. The child's 7 months old. She's got 2 other children. She's suffering from what her husband describes as postpartum psychosis. She goes about strangling her 5-year-old daughter, Cora, 3-year-old Dawson, and 7-month-old Callan with exercise bands, and then in an attempt to take her own life, jumps out of the second floor window. She is paralyzed now from the waist down because of that. Her husband, his name is Patrick. My heart goes out to this man. This man has lost everything. I can't imagine what the living nightmare that this man has, to have lost his children and then realize that his wife is responsible for that. And he has said, and I thought this was powerful, I wasn't married to a monster. I was married to someone who got sick. And that broke my heart too, because there has been no allegations, no evidence of abuse in that house. This is not a Emmanuel Haro type situation. This is a woman that he says was suffering from some sort of bad mental crisis brought on by postpartum, what they describe in medical journals as postpartum mood and anxiety disorders. And her defense is claiming that she suffered from postpartum psychosis, which is incredibly rare and only affects about 1 in 2,000 women. I know that she was on medication at the time, but there's also a lot of planning that went into this. Apparently, she had asked her husband to go out and run some sort of errand so that she knew she had time at home to commit this horrible act. Just a horrific case. In any case, she was in court she'll be in court, tomorrow for a pretrial hearing. Right now, her trial is currently set for February of 2026. I imagine tomorrow we're going to be hearing much more about this defense and what experts they want assigned and how that's going to all play out in court, because is this going to turn into some sort of insanity defense? I imagine that it will. Especially if hearing what the husband, the father, what he believes to be true, at least. There was also one issue that's kind of, I think, left hanging in this case, and that he gave an interview to the New Yorker magazine, and the prosecution wanted their hands on those notes. And I think the judge has yet to decide on that. But that case, like I said, coming to court tomorrow and will be set for trial in February of next year. And we'll see if that remains the same. All right. Moving on with our stream of awfulness this evening. This is a case out of North Olmsted, Ohio. Bionca Ellis. She is charged with murder of 3-year-old Julian Wood. The story goes, is she goes into a store and steals some knives from a thrift store, walks outside into the parking lot and stabs poor Julian in front of his own mother to death. This case has got some interesting stuff for us to get into because it deals with this kind of constant misunderstanding I feel that exists between the idea of competency and insanity. She was at one point in September of 2024. This murder took place on June 3rd of 2024. By September, she is declared incompetent by the court. A medical psychiatric evaluation is done, and that says that the defendant, the results come back, the defendant is incompetent to stand trial, but there is a substantial probability of restoration to competency within the statutory timeframe if provided with a course of treatment. And that's what they did. People bounce in and out of competency, i.e. Lori Daybell. By February of 2025, Ellis is deemed competent. Competency has to do with your present mental evaluation. As you sit in court today, are you competent or incompetent? And competency has to do with the question of a very low hurdle of, do you understand the proceedings? Do you understand what you're charged with? Do you understand who the judge is, who the prosecutor is? Are you able to the barest of minimums, assist in your own defense? If you can satisfy those incredibly low hurdles, then you are deemed competent. Competency is different, though, from insanity. Insanity has to do with your mental state at the time of the crime. And were you, by reason of disease, crisis, injury, there you go, therapist, absolutely right. Unable to appreciate the consequences of your actions. And that is what the defense is pleading in this case. They have entered a plea of not guilty by reason of insanity. So it will become, this is not going to become, again, a whodunit. This is going to become is this person insane at the time? Probably a bifurcated trial there in Ohio. Interestingly enough, too, the defense recently asked for the jury to be sequestered. Very rare in this case. The judge says the court believes that it can mitigate any prejudice with clear instruction and an order to the jury once it is selected. So the judge denied that, and trial begins on Wednesday. Again, a heartbreaking case. Just if you want to, it literally is the definition of a random act of violence. And a family that will continue to suffer loss for now until eternity. So that's starting on Wednesday. All right, on Friday, finally, we can step out of the realm of these little children losing their lives, but no less creepy. Sean Combs, he is coming back for sentencing. As you know, I think this case was a win for the defense. He was charged with racketeering. He was charged with sex trafficking. And he was found not guilty of both of those. Both of those important. There he is having a moment with his maker, thanking him for that. Both of those could have landed him in prison for the rest of his life. Not guilty on both of those. What he was convicted, though, however, was 2 counts of transportation for engagement in prostitution, or what is oftentimes referred to as the Mann Act. His defense has tried to challenge that, saying it's an archaic act. I'm not going to get into the weeds on this whole thing, but the history of this act is rooted in, racial prejudice in this country. it has gone through different amendments. And as it exists today, it simply stands for the proposition of if you transport someone across state lines for the purpose of prostitution, that is a violation of this law. That is the crime, and that is what he's been convicted of. And he's looking at 10 years maximum on each of those. The prosecution is asking for anywhere between 4 to 5 years on each of those counts to run consecutively, I imagine. But the defense has come back and said, at best, he should be sentenced to 14 months, which essentially would be credit time served for the amount of time that he's been in. What is the judge going to do? Judge Arun Subramanian. Well, this judge has twice denied him bail. You remember, Sean Combs was essentially willing to give up everything to get out. I think it was into the hundreds of millions of dollars he was willing to post in some sort of bail package, and the judge denied that. And even after being acquitted of the more serious charges in this case, and after watching the trial, which did not go well for the prosecution, the judge still denied him bail, even pending sentencing. Now, what does that mean as far as what we expect the judge to do? And I'm going to give you such I'm not going to satisfy your curiosities here. I'm going to give you kind of a coward's answer because I could really see it cutting both ways. I could see this judge having witnessed everything. Though the prosecution did not prove their case, what they did prove is that Sean Combs was kind of an unabashed tyrant for a couple of decades in a row and treated people awfully. And nothing's going to change what we saw take place on that video with Cassie Ventura. That was horrific stuff. That was a crime being committed in front of everyone's faces, but he wasn't charged with that. So I could easily see this judge saying, listen, you had some clever attorneys and you paid quite a bit for them and they did an admirable job and you got out of this, but I saw what I saw and I'm allowed to allow the holistic view of your conduct to play a role in my sentencing. I could also, though, and this is something I hope is not true, I could also see him saying the reason why he denied him bail was to give him more custody time so that he could sentence him to time served based on all of this. I don't know. Maybe I'm being outlandish. Maybe I'm being cynical. These federal judges are usually very tough, usually very strong. I don't think this judge is any fan of his. And I don't think that he's willing to undercut the prosecution that much, but he might split the baby and give him somewhere, in the range of 4 to 5 years total, 4 to 5 years on each count and run them concurrently, pardon me. I don't know. We'll see. In any case, that's still a win for Diddy. I mean, at that point, he's still looking to get out in just maybe another year or two. Pretty incredible stuff. The guy literally, I even said this. I can't believe I said this. I even said this, that when he got denied bail, that he had already breathed his last breath of free air. And now this man very likely will be, walking the streets before the Olympics here in Los Angeles. I mean, it's fairly incredible, the turn of events for Sean Combs. All right, last case. Finally, like I told you, busy week. Annie K says, can they charge him with new charges? They can charge him with stuff as long as it wasn't related to what they already charged him with. I mean, he's been tried and convicted for all of that. But if they've got, if they realize he's good for a murder somewhere down the line, or if some other unrelated victim that still, hasn't blown the statute of limitations problems, sure. I mean, it's not like he's acquitted of everything he's ever done. But I believe this was everything they could find. This was their best shot. They gave it their all, and they They just didn't have it. And I don't know if I can entirely place the blame at the feet of the prosecutors, or if it's just, it wasn't there. The crimes were not there. You essentially what this verdict says is that the jury believed he did the things he did, but they don't believe that they was done without consent. I don't think the jury believed the victims in this case were entirely doing this without consent. Now, that might shock a lot of you, but consent, as it needs to be proven in court, is not about what takes place between somebody's two ears. It's not about somebody hating what they're doing. It's about somebody exhibiting, vocalizing, demonstrating for a reasonable bystander that they are not consenting to what's taking place. And if that person is sending text messages and communication saying, I can't wait for our next freak off, or helping to plan these freak offs, or talking about him affectionately, that begins to really have jurors question whether or not they may have hated it. They may have not liked it. They may have felt gross about it. They may have been disgusted by it. But you could be disgusted by something and still give your consent to do it. And I think that's where the jurors ended up on this. Certainly not beyond a reasonable doubt in their view. Great question, though, Annie K. All right. Our last one. Kimberly Sullivan. This is the case out of Waterbury, Connecticut. There was a fire at a home on February 17th, 2025. And when first responders arrived to that home, they find a 32-year-old man who has not been identified. He is the stepson of Kimberly Sullivan, they find out. He is 32 years old, and the man weighs 68 pounds. And what they begin to discover is the absolute horror that he has been living for the last 20 years. For 20 years, he has been in captivity. 22 hours a day, he was locked up. He had no shower for the last 2 years of his life, and he was basically surviving off of 2 sandwiches a day. 68-pound, 32-year-old man who was so desperate for help that he started a fire knowing that people would respond and hoping that that would save his life. She has been charged with kidnapping and various assault charges, but she's out on bail. Her bail was set at $300,000 and she's out on bail. So she has a pretrial hearing on Friday. She's claiming this was not kidnapping. She's not holding him against his will. He's an adult. He could have left at any time that he want. Well, 20 years ago, he certainly wasn't an adult. A person can still be locked up as an adult. I don't know what other kind of abuse this person was suffering, what kind of mental, emotional abuse this person was suffering. Obviously felt their situation was helpless to the point that they decided they're just going to burn the house down and either die in it or get rescued by it. Kaylin points out the father passed away a few years ago. He was apparently in on the abuse as well. Here's my beef in all of this, though. First of all, my beef certainly is with her. She is the criminal here. She's the one that if all of this proves to be true, she's the one that should go to prison. But the Department of Child and Family Services the last time they performed a welfare check on this man was in 2005, 20 years ago. Their statement, they've been scrambling to explain themselves. How does a child never go to school and nobody notices this? How does a child simply vanish and nobody notices this? How do they have a welfare check? He was on their radar. They checked on that. I haven't had DCFS turn up to my house ever. They checked on his welfare and then just closed the file for 20 years. Their statement was the department is currently reviewing them, meaning their records, for purposes of assessing our work with the family over 20 years ago and to inform any need for current statutory or practice reforms. This just sickened me. The bureaucratic bullshit of all of it, that is going to be their response to abandoning a child for 20 years to be tortured to near starvation and death. Like, again, the crime was committed by Kimberly Sullivan. She's the one that should go to prison. But are you telling me that you cannot do a better job than what took place here? I don't know. Just a fairly shocking case on many different levels. And that's one of the levels that bothered me today. Anyhow. All right. Did I miss any questions that I should get to? Carrie C says the defense attorney is something else. What else did I miss here? All right. Nothing, I guess. All right. Let's get to some announcements and then I'll get you guys out of here. Oh, I'm running a little overtime. I permit myself to take 1 hour of your time and I'm running a little bit over. So, first of all, have you checked out thecourtroomconfidential.com? That is our website. We put a lot of work into it and it's a great place to go for certain things. One, if you would like to ask us a question that didn't get answered tonight and you want to leave us some voice message about that so that I can answer it on Sunday Funday, you go to thecourtroomconfidential.com. If you want to learn about membership and how you can be a part of our growing community and all the perks of membership. And by the way, we got a lot of perks, plenty of perks. Check out all that is available at thecourtroomconfidential.com and how to become a member. It's also the easiest place to go to become a member because doing it sometimes on your mobile device will give you fits. Fala, damn it, gifts 5 Courtroom Confidential memberships. Again, to those 5 lucky people, check out all the benefits. You're going to love it. And thank you so much, Fala, damn it, for that. And then finally, merch. What is this I'm wearing? Flora Paris says, Josh thinks we want to be let out of here. What am I wearing here, Tiff? What is this? Don't say chalky mint, Kaylin. You're not permitted to touch the keyboard. Lagoon Blue says, Afton. I like that one. Christy J says, chalky mint. Cute. Shy Gal says, princess mint. No. Oh, I like this one. Barbara Russell says seafoam green. What is it? Afton wins. What does that mean? Which one is it? Lagoon blue. Oh, I like that. I don't think the screen even picks up what a nice color it is. But if you like this color, we've got plenty more like it. We've got other designs, men's and women's cuts, plus a bunch of other stuff. Plus we've got your Let's Get Juiced tumblers, your Pinot on the go tumbler, a bunch of other stuff, mugs, everything you could want, every stocking stuffer you could possibly want. Check it out at thecourtroomconfidential.com. What did you miss this weekend? Well, we had our weekly roundup on Saturday, as always. We talked about Rex Heuermann. We talked about Barry Morphew. We talked about David. We talked about Luigi Mangione. Really interesting week. Please check it out. That's up. If you haven't checked it out, we put a lot of work into it. I hope you enjoy it. On Sunday, we did not have our Sunday Fun Day. We apologize for that, but instead we gave you a hot lasagna of an episode, and we hope that you enjoyed it. It is something we have put a tremendous amount of work into, and that is our case notes series on the Gilgo Beach serial killer. Kaylin outdid herself. I give Kaylin so much credit for this thing. She worked so hard and so long on making this as best as we possibly could, and I challenge Dateline to work on with the budget that we got and the amount of people working on it and do a better job than what we did. So check that out. Everything you would ever want to know about this case as it leads up to trial. Bess Nancy says it was a great episode. Thank you so much. Barb Russell says it was exceptional. Thank you so much. Appreciate that. If you guys haven't checked it out, Shy Gal says it's amazing. Afton says it's fantastic. And Kaylin is the queen she is. Please check it out if you guys haven't watched it. But then, here's some things to stay tuned for. And this is why things get a little goofy this week. One, on Tuesday, that's tomorrow, I will be on Gavin Fish's channel that evening. We're going to be talking about Ellen Greenberg. He is, of course, the Ellen Greenberg aficionado. That will be at 4:30 p.m. Pacific, 7:30 Eastern. And we're going to have a long discussion about the legal ins and outs of that case and where things stand right now. So please go to Gavin Fish's channel. There's the link. And send him a hi, send him a hello, send him some love from Courtroom Confidential, send him some juice boxes, let him know we roll heavy. Wednesday, I am flying out to New York, but we are still going to have a Wednesday night live. Now, we're going to record it ahead of time, but release it on Wednesday. But because we can't do the live, and I know you'll be upset, we hope that you won't get too mad because we're bringing you more Kevin Fixler. You're going to get your Fixler fix because there has been some new video released of Brian Kohberger's behavior, certainly afterwards, and I think ahead of time. And Kevin's going to help us walk through all of that. So that will be a live premiere on Wednesday at 5 p.m. Pacific, 8 p.m. Eastern. It's live, so you can be in the chat and hang out with everybody. But it's not live because we're going to record it ahead of time because I'm going to be on an aeroplane that day to New York, which brings me to Saturday. We're also doing our weekly roundup, but it will again be kind of a weird from the hotel room weekly roundup, but you're going to love it. We're going to do as good a job as we possibly can. We did something similar when we were in Denver for Crime Con, but I'm going to be in New York doing some more coverage and stuff for Fox News. If you want to check it out, you'll be able to find me for, maybe on a couple of times between Wednesday and Friday. And then Sunday Fun Day is back. Regardless of where I'm going to be, I will be back. Hang on to your passport. Do not lose it, says Barb Russell. Why would I need to do that? Believe me, I have now become one of those weird people that, like, I constantly check my pocket for my passport when I was traveling. I'm not going to lose it. I promise you all. Sunday Fun Day is back. Leave us a message. We need some messages, by the way. We were a little low on them the last time I checked, and I'm going to work on it during my downtime in New York. And we will be live, same place, same time, live at 9 a.m. Pacific, noon Eastern, here on Courtroom Confidential, answering all your questions. Crime Con, speaking of it, it's coming up in Las Vegas, May 29th through 31st next year. It's going to be fun. We're going to be there. We're going to be doing a booth. We're going to be trying to do meetups and all sorts of other fun stuff. JD says, Human Case was well done. Love it. Yeah, both Mary Murphy and Alexis Linkletter are on it. If that's a draw to you too, incredible interviews with both those ladies about their in-depth knowledge of that case. If you want to go to CrimeCon, or if you just want to have an excuse to go to Vegas, it's coming up May 29th through 31st, and we will give you a discount code, and that is Courtroom, all one word, all in caps, and you can get 10% off at checkout. And finally, let me say thank you to some of our newest members. This list continues to grow, and I love it. Cara LeBlanc, Amanda Kay, Charlene Salter-Welch, Legally Blonde, Laura, Luca 0821, Dorothy J, Marisol, Raven, Evie Guarini Moreland, Lenita Patterson, Carol H, Leaf It To Me, get it? Jody and Jenny C. Look at that. I feel like that was fairly flawless. Thank you guys so much for becoming members. If you want to check it out, the membership program, there's all the perks. There's all the different levels that you can join at. And go to The Courtroom Confidential for more information. Thank you so much to Kat for being a member for 12 months. Loved your Rex Heuermann case notes episode, by the way. 10 of 10. That, by the way, if you can do the math, is as high as you can get on the 1 to 10 scale, a 10. Thank you so much, Kat. Appreciate you. Emily Flotilla for being a member for 7 months. Lovely meeting you at Crime Hunt. It was lovely meeting you as well. Thank you so much for being your member and all of your support. Thank you to our mods, Afton, Shy Gal, Kathy, and therapists you know for all the hard work that you do. Thank you so much, Kaylin, for all the hard work that you do. I can't thank you enough for just running at a constant level of exhaustion all the time. And it proves the results are fantastic. So thank you so much, Kaylin. And Tiffany, thank you so much for putting up with me and being the best thing that ever happened to me. All right, you guys, have a wonderful rest of your evening, and I will see you all on Wednesday. Take care, everybody.